What is guardianship transfer? Have you ever wondered what happens when someone under guardianship moves to a new state? This is where guardianship transfer comes into play. Guardianship transfer is the legal process of shifting the responsibility and authority of a court-appointed guardian when the ward relocates. The ward is the person under guardianship, often due to incapacity or disability. When a ward moves, the existing guardianship order does not automatically follow them because guardianship is governed by state law. Each state has its own rules, which can make the transfer process necessary. So, how does this process work? It typically involves a few key steps. First, the guardian must file a petition in the original state's court. This petition requests permission to transfer the guardianship to the new state. The court will review the situation to ensure that the transfer is in the best interest of the ward. If the court agrees, it issues a provisional order allowing the transfer. Next, the guardian takes this provisional order to the new state's court. Here, they file another petition along with the original state's provisional order and any other required documents. The new state court will examine the case. If they are satisfied that the ward's interests will be protected, they will issue their own provisional order accepting the transfer. Finally, the guardian must return to the original state's court with the new state's provisional order. The original court will formally discharge the guardianship, ending its jurisdiction. The new state court will then take over full guardianship authority. Most states follow the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act. This act provides a streamlined process for transferring guardianships across state lines. However, not all states have adopted this act. In those states, the guardian must start the process anew, which can take more time and cost more money. There are some important considerations for guardianship transfer. The move must be permanent and in the ward's best interests. The guardian should have reasonable plans for the ward's care in the new state. Additionally, close relatives of the ward must be notified about the transfer. This gives them a chance to object if they believe the move is not appropriate. If objections arise, courts may hold hearings to determine the legality of the transfer. From an elder law perspective, transferring guardianship is essential when wards relocate. This is often the case for elderly individuals moving closer to family or into specialized care facilities. Properly transferring guardianship ensures that there is no interruption in the protection and management of the ward's personal and financial affairs. Because guardianship laws can be complex and vary by state, it is a good idea to consult an experienced elder law attorney. They can help navigate the transfer process and ensure compliance with all legal requirements. This way, the ward's interests are safeguarded and the guardian's authority is recognized in the new state.